the space for naming and shaming, which also works very well through the work of the production of these reports. Mr. Chairman, the Law Commissioner and Ombudsman are Human Rights Commission, as you are aware. For Malawi, this is a unique arrangement that ensures monitoring of human rights violations in law through law reform, and the monitoring and corrections through administrative justice processes through the Office of the Ombudsman, who is also a Human Rights Commissioner. Malawi considers this an innovation in the Constitution, which ensures a holistic approach to the promotion and protection of human rights in Malawi. The major challenge for the Human Rights Commission is funding, resources, which is across the board in the country, because the country, Malawi, is not a very rich country, if I may put it that way. So this is a common problem for all government institutions in Malawi. The other issue that your committee raised relates to non-discrimination, issues of equality between men and women. Your committee has raised the issue of specific provisions in the Penal Code, Section 137, 153, and 156, which deals with LGBTs, the rights of LGBTs. This matter has been referred to the Law Commission to carry out law reform as a state institution mandated for that task. I should report to your commission that the review has stalled due to lack of financial resources to implement the law reform program, but the political will is there. Malawi has not set up a mechanism to specifically monitor cases of violence based on sexual orientation because we have not received any complaints, and there are no statistics submitted to government, no research done on this issue. There's basically no data. The other issue that the committee has raised relates to illegal practices against women, widows. I'm glad to mention that Malawi enacted the Deceased Estates Wills, Inheritance and Protection Act in 2011 to penalize property grabbing with both fines and imprisonment. There's also the Gender Equality Act, which has been recently commenced, that criminalizes what have been termed harmful practices, which may be social, cultural, or religious, and which on account of gender, sex, or marital status undermines the dignity, health, or liberty of a person. In addition, there's a proposed law on HIV and AIDS that target the criminalization of sexual cleansing in the wake of the epidemic. Mr. Chair, the Minister of Gender, the Minister responsible for gender, has led campaigns against violence, targeting international commemoration days such as International Women's Day, 16 days of activism against gender-based violence. So this is an issue that is on the agenda of government, and sensitization processes are ongoing. I should, however, mention that the tabling of the Marriage, Divorce, and Family Relations Bill has delayed because of two outstanding issues: the outlawing of polygamy, which we are still consulting on, and the minimum age of marriage. The minimum age of marriage is a constitutional issue, and the proposed amendment to change the minimum age of marriage requires a referendum, as that provision is protected. But the minister responsible, that's the Minister of Gender, is aware of this matter and has approached government on the way forward on this issue. And in terms of training and sensitization on the Gender Equality Act, this is ongoing from the perspective of the Minister of Gender, but also the Human Rights Commission, which has been entrusted with the task of implementing that act. Mr. Chair, the other issue raised by your committee relates to the right of life, in particular, the death penalty. And on that issue, I would refer your committee to the responses, the comprehensive responses that we have indicated in the list of responses in paragraph 5 of our response. There's also the issue that has been raised by your committee on extrajudicial killings in Malawi. There was mention of Edison Siska, and our report is that 3 officers are being prosecuted in relation to that person, in relation to that death. There was also the issue of Fanikizo Piri as another killing that happened at the hands of, I think, police officers. Malawi considers this a very unfortunate case. No prosecution was ever commenced, no arrests made. But in view of the time lapse, it is very unlikely that prosecution will be conducted because of evidential challenges. The other one mentioned by your committee was Robert Chasoa. In relation to that one, inadequate investigations were carried out by the police, but the Director of Public Prosecutions has directed the police to conduct further investigations. This request is still pending, and we're waiting for feedback as a ministry from the police in terms of the outcome of those further investigations. Mr. Chair, your committee also raised the issue of police brutality in the context of prohibition against torture, the obligation on prohibition against torture and cruel and inhuman treatment. In terms of police brutality, there are a number of initiatives that have taken place in Malawi, and I refer your committee to our response in paragraph 7. And just to mention that among the initiatives to stop this practice in cells and prisons, the police has introduced a human rights course at the basic recruit training level. There's also a human rights manual and a source book on human rights for use by police officers that has been developed. In addition, we have a lay visitors scheme in place as required by the new Police Act, which allows local people to inspect conditions of detention through committees chaired by lay persons. Though the Independent Police Complaints Commission has not yet been put in place, there are internal mechanisms that have been put in place as a stopgap. As I'm talking now, the police has set up a unit which is investigating violations or complaints against police officers. And we have a consultant supported by DFID to help us define the roadmap to the Independent Complaints Commission, the setup of the Independent Police Complaints Commission. The major challenge in setting up that institution has been the lack of resources. Government at the moment is looking at reducing the number of institutions because of this challenge, but it's a matter that is on the table, and government is trying to find ways of how to come up or addressing this issue. Your committee also raised the issue of spousal rape. And I should mention here that at the moment, there's no legislative or policy plans to criminalize spousal rape in Malawi, but it's not a closed issue. We do not have female genital mutilation in Malawi, but the way our penal laws are, even if we had it, it will still be properly addressed in our penal laws if it happened. So I would also refer the committee to paragraph 9 in our responses. The other issue that I want also to mention as way of summarizing the responses relates to the legal aid, the provision of legal aid in criminal matters, and to stress that the new act, the Legal Aid Act, is very comprehensive and very permissive. It does not prohibit access to lawyers by people in custody, but rather regulates provision of legal aid in light of financial constraints. We consider that this is in line with international practice, and the test that has been incorporated under that law reflects an international practice because it zeroes in, it focuses on interest of justice, looking at the seriousness of the offense, and also considers whether the case relates to or involves a substantial question of law. And then there's the issue of whether the person has insufficient means to engage a lawyer. In terms of alternative measures to sentencing in Malawi, in a bid to reduce prison population, we have community service under our laws. The courts can impose suspended sentence, security to keep the peace and be of good behavior, fines, compensation, forfeiture, as just as illustrations of alternative sentencing mechanisms that we have in Malawi. Mr. Chair, the other issue that was raised by your committee relates to the right to fair trial and the measures that government has taken to reduce backlog. I'm happy to report that to your committee that government appointed 10 judges to the High Court in the year 2013 and 2014, and 2 judges to the Supreme Court. Government has also trained 57 paralegals to become lay magistrates in a bid to help efficiency in the court systems. In relation to the right to recognition as a person before the law, and particularly on the issue of people with the rights of people with disabilities, government enacted a law on disability, which is very comprehensive, and I also refer to, in terms of the contents of that act, I refer to the responses that we have submitted to your committee, which are very detailed. The other issue that was raised by your committee relates to prohibition of arbitrary or unlawful interference with privacy, particularly the issue of search without warrant by the police. Mr. Chair, Malawi, the law that Malawi has put in place has built-in safeguards. You'll find that though this is permissible in Malawi, the search without warrants, there are safeguards. The police who can do this has to be of a certain seniority. He has to have reasonable grounds, and these reasonable grounds have to be put in writing for suspecting presence of the thing to be searched for. He must also illustrate that undue delay might cost the search and submit a copy of record to the owner of the place where the search took place. And is also required to bring the item, if found at the premises, to the nearest magistrate immediately. Mr. Chair, on the issues raised regarding the bill that is pending before Cabinet on HIV/AIDS prevention, the position of government at the moment is that we are going by what is provided in the law. The law requires, this bill emanates from the Law Commission, emanated from the Law Commission. The law requires that every report that emanates from the Law Commission, including the bills, should be presented to Cabinet wholesale. So this report and the bills are before Cabinet at the moment. The issues that were raised, I think additional issues after the report was done, are expected to be brought to the attention of the Cabinet by the responsible ministry. Too many issues. On the issue of freedom of opinion and expression, in particular Section 56 of the Penal Code, empowering the minister to ban newspapers, Mr. Chair, that provision was repealed. It's no longer part of the laws of Malawi, so the concerns were addressed. In terms of journalists which were arrested and the status of their cases, I think comprehensive information is provided in our list of responses, including the names of the journalists and the status of their cases. But I'm also glad to mention that an access to information bill is pending before Cabinet, and the plan is that it should be submitted to Parliament in September, Cabinet having approved the policy. The other issue, I think, raised by the committee was to do with the measures that have been put in place for the protection of minors in relation to Articles 12, 23, and 24 of the Convention. And our response is that in Section 16 of the Constitution, of our Constitution, is very specific about protection of minors against sexual exploitation, labor. And also in the new penal code, in the amended penal code, we have introduced offenses against morality involving children. The new Child Care Protection and Justice Act has also provided for offenses against undesirable practices against children, including the criminalization against child trafficking, abduction, and forced marriage. There's pending legislation on trafficking in persons, which criminalizes exploitation in general and has also included protection of women and children. And then there's the issue of the minimum age of marriage, which has met with a constitutional hiccup, but which the government is trying to address. I also wish to report that the Law Commission has finalized the report on the review of Adoption of Children Act in order to introduce protection for children being adopted across international borders. In summary, Chair, these are the responses that Malawi has submitted to your committee, in addition to the detailed, I think, statistics and figures that has been submitted in the formal report, in the formal response that has been submitted. I thank you, Chair.
And I thank you, Dr. Band. That was a model summary, and that you were able to produce it in that way under the circumstances was very much appreciated by the committee. So we now go to the first round, which is issues 1 to 12, and the floor is now open to colleagues who want to engage on those. The first speaker on my list is Ms. Waterval. Ms. Waterval, you have the floor, ma'am.
Thank you, Mr. Chair. Let me first extend my warmly welcome to the distinguished delegation of Malawi and congratulate them on the initial report. I am responsible for the issues 1, 2, and 3. And I hope that this constructive dialogue will be a very constructive one this afternoon and tomorrow morning. With regard to issue number 1, at first I was confused by your reply stating that the covenant cannot be invoked directly before your courts, while you stated in the initial report, and that's in paragraph 8, and I quote, Section 211 of paragraph 1 of the Constitution provides that any international agreement ratified by an act of Parliament shall form part of the law of Malawi, if so provided for in the Act of Parliament ratifying the agreement. International agreements entered into before the Constitution, international agreements entered into before the Constitution came into force also form part of the law of Malawi. Malawi ratified the covenant on the 22nd of December 1993. The covenant, therefore, forms part of the law of Malawi. So that was the confusion. But the following sentence is, Malawi is a dual estate. And then it became clear to me what you meant. Further, you state that the Law Commission is reviewing all inconsistencies of local law with the covenant. My question is, has the Law Commission enough funds to do its work, taking into account the statement in the last sentence of paragraph 8 of the replies, which I will address in a moment? Have Malawi received laws? No, sorry. Have Malawi reviewed laws regarding the restrictive interpretation of the abortion law, and also laws which discriminate against women? What is the result of the review, and has the Law Commission tabled any proposed bills before Parliament? What is the role of the Law Commission when the law in itself is in accordance with the covenant, but the application contravenes the covenant? So what advice does the Law Commission gives the government? With regard to issue number 2, and that's on the National Human Rights Commission, can you elaborate more on the issue of financial and human resources of the Commission? Can Malawi provide us with statistical data regarding the number of recommendations issued by the National Human Rights Commission and the number of the recommendations which were implemented? Is the National Human Rights Commission accredited A status according to the Paris Principles? Has the National Human Rights Commission ever investigated violence against LGBT persons? Because we have information that in 2010, Gift Trappens, on behalf of the Center for the Development of People, submitted a case to the National Human Rights Commission, but he never got an acknowledgement of the receipt of the case. Maybe you can elaborate on that or comment on that. Maybe you can also elaborate on the appointment of the committee members or commissioners of the National Human Rights Commission. And I also like to know the position of the National Human Rights Commission on the sexual orientation, their position on that, and what is their advice to the government. With regard to issue number 3, I will refer to the last sentence in paragraph 8 of your replies. And the last sentence says, and that's, I don't understand, that's why I ask your comment on that. However, due to lack of funds, the review has stalled, and there are no findings on the issue. So I don't understand, is the one the consequence of the other, or maybe you can elaborate on that. And with that, I thank the delegation for their answers in advance, and I thank you, Mr. Chairperson.
Thank you very much, Ms. Vatafal. And the next speaker on my list is Ms. Majordina. Ms. Majordina, you have the floor, ma'am.
Thank you very much, Chair. First, let me also extend a warm welcome to the distinguished delegation from Malawi, and I look forward to engaging constructively with yourselves in the next few hours. My issues are 4, 8, and 12. On issue 4, steps taken to ensure that persons who engage in illegal practices targeting widows, such as appropriation of property, sexual cleansing rituals, widow inheritance.
So apparently it's not coming through on the. Have you put these?
No, we can. Yeah, but she's speaking so softly, so we can't.
But you can, if you wear these, then that should do the trick.
And then you put it in English as number 2.
Okay, you there?
Yeah.
I'm sorry, Ms. Majordina. The delegation been hoping to hear you without benefit of earphones, and unfamiliar with your gentle, dulcet tones. So I wonder if you wouldn't mind just starting again, now that they've got the earphones available. Thank you, Ms. Majordina.
Thank you, Chair. First, let me add my warm welcome to the distinguished delegation from Malawi, just like my colleagues have done before me. And I look forward to engaging with yourselves in the next few hours, unlike in the last examination of Malawi's report, when we didn't have a written report. So I hope this time it will be much more, it will be facilitated by the good reports that you have sent to us in good time. I'm dealing with issues 4, 8, and 12. And I'll start with issue 4 on steps taken to ensure that persons who engage in illegal practices targeting widows, practices such as sexual cleansing, rituals, widow inheritance, are prosecuted and punished. I'm sure, or rather let me say I hope, at the risk of being provocative, that the delegation will agree with me that while such practices are accepted as normal by the majority of people in Malawi, they in fact violate women's rights to equality, rights that are at times considered in Malawi to be in direct conflict with cultural norms. This is not the first time the committee brought this up. We brought this matter up in 2011, and we issued recommendations in our concluding observations where we said that Malawi should put an end to these practices, prosecute and punish those who are convicted. I was therefore surprised that the response to the concluding observations we submitted to Malawi authorities was scanty. We were just told that Parliament is expected to consider 2 bills on marriage and divorce and gender equality. There was nothing else in the response to our recommendations. But I'm also surprised that the state report only refers to the Constitution in this regard, specifically Section 24, which provides for the prohibition of discrimination. The state the state responses do not address the main concerns of this committee as reflected in the issue. Whether people who engage in such illegal practices are prosecuted and punished if found guilty. Surely, it cannot be that Malawian authorities have never had to address such common practices that I would imagine take place all the time. I have been witness to some of this, because I've lived in Malawi for a very short time, and in that short period of time, I did see some of these practices taking place. And this was in a rural setting. And I would imagine that this is still the case, even though what I saw was many, many years ago. So I therefore want to repeat the questions raised in issue 4 slightly differently. First, what is being done to convey the message that appropriating widows' inheritance, sexual cleansing rituals, widow inheritance are absolutely unacceptable to a government that has a strong commitment to human rights? We're told by the Malawi Human Rights Commission that this is indeed a commitment we are making not only to us, but to the rest of the Malawi population. According to the state report, efforts to eliminate these traditional practices include public campaigns and training of public officials. What I want to know is, what has been the impact of these campaigns and training programs? Are people better informed that these practices are wrong? How many cases have appeared before Malawi courts? And how many perpetrators have been fined or imprisoned? What further protections will the draft bill on marriage and divorce provide to widows, given that the Deceased Estates Act does not specifically mention widow cleansing and widow inheritance? And lastly, why is it taking so long for the draft bill on marriage and divorce? Yes, indeed, the head of delegation referred to this matter a bit, but I would like you to elaborate more on the reasons why it's taking so long and whether it will, in fact, improve the situation of widows when it is enacted. I now turn to issue 8 on domestic violence. There has been some limited progress to combat domestic violence. I'm happy to note, according to the responses, there are now victim support units based in community police services. We have also been given some data for last year, and but this data has not been disaggregated as we requested in the list of issues. We've also been told that some public awareness raising is being conducted by the police. There is, however, no indication in the written replies on the number of investigations, prosecutions, and sanctions that have been meted out, and it is not clear whether the victim support units that are meant to help survivors are equipped to investigate and prosecute perpetrators. Also, the government replies do not provide any statistics on how many women receive services from these support units. In the past, this committee has recommended that states should take measures to encourage women to report cases of domestic violence. And from what we have received from government, there's no indication of obstacles faced by women when they approach police stations and report abuse. A recent study cited by NGOs found that only about half of women affected by domestic violence ever seek help. And out of those, only 3% have gone to these police victim support units. I wonder if the delegation would comment on this and perhaps correct me if I'm wrong, or correct this study that has been cited. Against this background, I want to quote from a statement made by the Honorable Minister for Gender, Madame Anita Kalinde, at the 57th session of the Commission on the Status of Women held in March 2013, where she reported that, and I quote, "To date, 30% of the reported cases of violence are prosecuted," end quotes. She did not provide any data to support this assertion. And again, I would be happy if the distinguished delegation could comment on this. And lastly, on domestic violence, I'd be grateful if the delegation could comment on why recent amendments to the Penal Code did not address calls for the criminalization of rape, and whether, this is a separate question, there are any plans afoot to train judges and other law enforcement officers, such as police and prosecutors, on procedures relating to how to deal with the issue of domestic violence. Lastly, on trafficking, we have asked a number of questions in issue 12, but on the question of data, statistical data, it seems there are no official statistics at government level. That we did not get in the replies. Neither is there information on numbers of persons prosecuted, convictions, and rehabilitation programs for survivors. It's all the same encouraging for me to know that the Child Care Act imposes a life imprisonment on perpetrators, and that the Ministry of Gender conducts awareness-raising campaigns on a regular basis since, I think, a few years back now. We've also received a lot of alternative information from NGOs, and from their reports, it seems that children are the most affected, but that government has made minimal efforts to provide adequate protection to trafficked persons and relies largely on NGOs to provide long-term care. And so I want to ask a number of questions on this issue. First, how many counseling and assistance centers have been set up by government? And do those victim support units in police stations have the capacity to respond to trafficking problems in addition to domestic violence? Secondly, are there any measures in place to conduct awareness campaigns among the public? Thirdly, is government ready to expedite the enactment of the anti-trafficking legislation? And then lastly, what programs are in place to train law enforcement officers on identification, investigation, and prosecution of trafficking cases? I thank you very much, Chair.
Thank you very much, Ms. Majordina. The next speaker on my list is Mr. Vatslashvili. Mr. Vatslashvili, you have the floor, sir.
Thank you very much, Mr. Chair. I would like to join my colleagues and welcome the delegation. Let me present the delegation with the questions related to the issues number 5, 6, and 11. Let me start with issue number 5. I have noted with regret that as it transpires from the State Party's report and replies to the list of issues, Malawi has no immediate plans of abolishing the death penalty, and consequently has no intention to ratify the second optional protocol. As you may know, this year the international community will celebrate 25th anniversary of the adoption of the optional protocol, and it could have been wonderful to learn about the strong message coming from Malawi in support of the right to life. Having said that, however, I still wish to express my appreciation with the fact that already for many years there is a de facto moratorium on execution of death penalty in Malawi. My understanding that this moratorium was in place prior to the decision of the High Court in case of Kafatayeni versus Attorney General, in which High Court ruled that the law which provided for mandatory death sentence for all murder cases was contrary to the Constitution of Malawi, as it failed to take into account individual circumstances of the case, mitigating factors, or even defendant's criminal culpability, and thus would result in inhuman and degrading punishment if it was to apply. This was in 2003 and 2007. While welcoming this decision, I can only add that this law seemed to be clearly in conflict with Article 7 of the Covenant. As far as I remember, High Court also found that the law was also contrary to Article 14 of the Covenant. Following this decision, however, it has been reported that Malawian courts were delivering death sentences after 2007 as well. The state party also reported that relevant sections of the penal code were amended in 2010, following the decision of the High Court, and providing the High Court with the discretion to choose between the death sentence and life imprisonment for persons convicted for murder. Could you please inform in how many cases the death penalty was imposed by the courts, and what is the number of commutations of the death sentence, especially after the 2010? This information was kindly requested by the committee, but unfortunately there were no information provided in the reports or the replies. I've actually read the decision on Kafataeni and should say that the crime committee, it was indeed dreadful. The accused confessed burning alive his 2-year stepson. Regardless of that, High Court ruled that it would be against Constitution to impose death penalty in such circumstances. Having this in mind, could you please inform the committee what are the crimes for which the death sentence have been imposed by the courts, especially after 2007 or following the amendments of 2010? And how does the law define the crime of murder for which the death penalty could be imposed? Does the law contain clear criteria that would guide the courts in choosing out of two options, life sentence and death penalty? And to what extent the law provides court with the possibility to take into account the specific circumstances of the individual case? I would also be interested to learn what is the intention of the state party with regard to the moratorium, which de facto exists in Malawi, whether it intends to keep it and for how long, and would it consider establishing a legal framework for this moratorium. My understanding is that the decision of the High Court of Malawi, including decisions on conformity of laws with the Constitution, could be appealed to the Supreme Court. So I would be interested to learn if there is a possibility, at least theoretical, at this point in time that the decision of High Court on this particular case could be overruled by the Supreme Court, or would the Supreme Court be barred from considering appeal on ratione temporis? And final question on this issue. Could you please also describe the criteria which was or is planned to be applied during the resentencing hearing of those currently being sentenced to death, if there is such a plan, obviously, to hear resentencing? Now let me move to issue number 6, which is also related to the Article 6, and in particular to the reports of cases of extrajudicial killings. In its general comment on Article 6, the committee stated, and I quote, "The deprivation of life by the authorities of the state is a matter of the utmost gravity. Therefore, the law must strictly control and limit the circumstances in which the person may be deprived of his life by such authorities." The reports submitted by the state party as well as NGO reports contain information about the police officers using the firearms against demonstrators, or police officers being convicted for manslaughter when they shot and killed suspects or killed individuals mistakenly identified as suspects. I would be interested to learn if police officers have clearly, if they have clear instructions and the guidance on the use of the firearms. Apart from the investigation, apart from the investigating the cases of murder or manslaughter by police officers, did relevant authorities engage in critical review of the regulations in place which provide against such kindness to the police officers when and how they, in what circumstances they may be allowed to use firearms? Now let me turn to the specific cases. I was pleased to learn that from the presentation made by Madam Head of Delegation that the investigation to the death of Mr. Siska, which occurred in 2012, has been accomplished, and police officers responsible for this murder were prosecuted. Unfortunately, the report didn't contain this information, and I sincerely thank the delegation for this update. Response of the state party in relation to the killing of Mr. Firi by police officers during the student demonstration is more disturbing. The state reported, and we also heard it during the presentation, that the family was compensated, but it was also stated that it is unlikely that the prosecution will be conducted because the case is fairly old. And so no person has been arrested in connection with this case when the murder did occur, and it was in 2001, as far as I know. May I ask the distinguished delegation to provide information about the actions taken so far by the relevant authorities, which made these authorities to think that there is no possibility to investigate the case, this particular case. It was also unfortunate to read that there have been no effective investigation of the death of a student and political activist, Mr. Robert Chasova. According to various reports, police initially stated that it was not a murder but a suicide, and even produced suicide notes allegedly written by Mr. Chasova as an evidence of a suicide. However, the post-mortem examination indicated that it was not a suicide, and later on, special inquiry commission chaired by the, as far as I know, the judge of the Supreme Court found that suicide note was fake and that this person was actually murdered. The report concluded that the manner in which police handled the matter was inherently unprofessional, and the police deliberately attempted to conceal the truth in this case. Despite of these findings of the Commission, which the findings were made actually in 2012, as it was reported by the state party, investigation is still ongoing. It's obvious that such a long investigation undermines the credibility of the investigative body, as well as creates sense of impunity and lack of and makes one to think that there is a lack of political will behind such a prolonged investigation. And I would be very much grateful to the delegation for any additional information regarding this investigation. Could you please also inform the committee? Could you please also inform the committee about the reasons for such a delay? It has also been reported that in 2011, police officers killed at least 18 unarmed protesters. The Special Inquiry Commission has been established, and to best of my knowledge, again, Human Rights Commission drafted a report on regarding to this incident, the case of the killing of the 18 people, of demonstrators. However, no investigation, and there was hope that it will result in investigation, but unfortunately it has not happened, and again, to best of my knowledge, this report has never became public. So any update on this issue would be very much welcome. Now let me move to the issue 11. The issue is related to the situation it relates to the work of the prison inspectorate, as well as some other issues related to the conditions in the prison. In the response to the issue 11, the state party indicated that it has been one visit of the prison inspectorate per year. I would appreciate if the delegation could explore a little bit on that. Does it mean that inspectorate visits every prison once a year, or there is just one visit in one prison per year? And what are the reasons for such a limited number of visits? I assume that the work of the institutions, like the prison inspectorate, requires certain funding, but if such a low number of visits are due to lack of funds, would the state party consider increasing the funding so this body adequately fulfills its functions? And I would also be interested to learn if the prison inspectorate responds actually to the complaints submitted by the prisoners, and if it is so, and organizes the visits in response to those complaints, and if it is so, what are the means of communication, how the inspectorate receives the complaints, or what is the source of information for the prison inspectorate in general? It has also been reported that the inspectorate has the power to carry out unannounced visits to prisons, but taking into account above information on number of visits, it seems that there have been no such visits organized or if it was more than one, then it will be obviously very useful for the committee to learn that. The State Party also reported that the Prison Inspectorate and the Human Rights Commission have mandate to inquire into any violation in prison or in police custody. I would very much appreciate information about the outcomes of such inquiries. In its reply, the State Party admitted that recommendations of the Inspectorate are not followed due to lack of enforcing mechanisms. So my question would be if there are any plans to put in place relevant enforcing mechanisms so the recommendations of the Inspectorate are being fulfilled. And could you please also provide any statistics whether there was some recommendation or some portion of recommendations from the Inspectorate followed and fulfilled by relevant authorities, and if it was so, then it will be interesting to learn the examples. I thank you very much in advance, and this is it for now. Thank you.
Thank you, Mr. Vatslashvili. The next speaker on my list is Mr. Bouzid. Mr. Bouzid, you have the floor, sir.
شكرا سيد الرئيس. بدوري أرحب ترحيبا حارا بوفد مالاوي وأشكره.
Thank you. I thank the delegation for the report, as also for the introduction and written and oral replies. I should like to dwell somewhat on question 7. Issue number 7 concerns the fight against torture and doing away with excessive use of force. You have given us details on the training of police officers. This training concerned human rights, and this is a praiseworthy venture. You said that in conformity with the 2007 Act on the Police Services, a unit was set up in order to deal with complaints against police officers. You said that 457 complaints were sent in and 449 cases led to compensation and reparation. Now, my question is, what was the number of police officers subjected to criminal prosecutions, and how many police officers were investigated? You said also that an independent commission was set up in order to hear the complaints. But today you have announced that that commission hasn't yet begun its activities. What are the reasons for this delay? Why has this not taken up its functions? What is the composition and what is the mandate of this commission? You also talked about lay visits, a lay visits unit made up of local people who are allowed to go to police premises. They are allowed to look at the premises. Who would be in these lay units? What would be their prerogatives? And what can be done if it is noted that proper conditions have not been respected? Do you have examples of this? Do you have examples of what this local unit has done in order to combat any wrongful conduct, and what is being done to improve the circumstances of the detainees? Thank you.
Thank you, Mr. Bouzid. And the next speaker on my list.
Yes, I remember people used to tell me that at the school as well, but it's sort of good to have something in between because, you know, you say, how are you getting on? And usually people...
Your microphone is still on, so we're listening to what's being...
Sorry.
I think it was what Mr. Flinterman was saying.
What did I say?
Sorry.
It's okay. Mr. Flinterman, please start again. You were being competed with.
Thank you very much, Mr. Chairman. I was saying that it's almost 3 years ago that our committee had the privilege of first entering into a constructive dialogue with a delegation from Malawi. But at that time, it was in the context of a private meeting of our committee, and only on the basis of a list of issues, plus some responses to the list of issues by the Malawi government. But at that point, I would like to express my appreciation for the fact that later on, when we had adopted, the committee had adopted its provisional concluding observations, the Malawi government sent comments on our provisional concluding observations, commenting upon the various recommendations. But you can imagine, Mr. Chairman, Madam Head of Delegation, how happy I am today to welcome the delegation of Malawi, a delegation from Malawi again, and this time in an open meeting of the committee, in an open meeting of the committee, which can be observed by non-governmental organizations. And I would like to express my appreciation for the vibrant civil society organizations in Malawi. And today we can discuss the situation of human rights under the Covenant on Civil and Political Rights on the basis, and I would like to stress that, on the basis of a very informative report, very informative initial report covering that long period between 1993 and today. And we can do that on the basis of our list of issues and the replies to the list of issues, and also on the basis of the important input of non-governmental organizations. And that brings me to the two issues that have been given to me to raise in our dialogue with the delegation from Malawi. And the first is the issue number 9, which reads, please provide information on whether female genital mutilation, FGM, is explicitly prohibited in the Penal Code, and what steps the State Party has taken to combat and prevent such harmful traditional practices. And the reply given to that particular issue, both in written form and today by the head of delegation, is crisp and clear. There is no FGM in the country. And I must say, that came as a surprise to me, both when I was reading the report and the replies to the list of issues, and today when you repeated, when the head of delegation repeated that particular sentence. Because we have information before us, information in the form of a report of the Malawi Human Rights Commission, a report commissioned by the Malawi government, in which the Malawi Human Rights Commission comes to the conclusion that practices of FGM take place in the southern region of Malawi. The words are added that those practices are quietly happening. Moreover, we have information from other sources which indicate that some ethnic groups, and maybe they are the same, practice FGM. And for that reason, I think the question remains, does FGM exist in the country? And if so, what measures have been taken apart from criminal prosecution? Because I'm the first to admit that criminal prosecution of FGM activities should be seen as a matter of last resort. There are other activities that can be expected, other measures that can be expected from the government, such as education, awareness campaigns, which could lead to the elimination of FGM. And we have been informed that criminal prosecutions are possible under the Gender Equality Act. And my question would be, have any such criminal prosecutions in relation to FGM taken place in the context of Malawi? That was my first issue. The second issue is issue number 10. And that's an issue which relates to the problems relating to pretrial detention. And it also raises the the issues, raises issues around legal aid. And I'm very, very grateful to the delegation for the replies, the written replies given to the list of issues. In particular, the very interesting and informative table which is contained in the replies and responses to the list of issues. But still, I have a few questions for further clarification. Because in the table, it is indicated that pre-trial detainees are held separately from convicted detainees. But we do have information from other sources that that is not the case. And for that reason, I would like to request from the head of delegation, if possible, more precise information on where pre-trial detainees are held and whether indeed they are kept separate from convicted detainees. I was very pleased to read from alternative information that about the so-called initiative of camp courts, which are organized by civil society groups in order to assist the government to reduce the backlog of cases and to eliminate the excessive pre-trial detention in Malawi. Nothing is said in the report by Malawi itself in its report and neither in the responses to the list of issues. And I would like to invite, through you, Mr. Chairman, the delegation to give its views on this very interesting public-private partnership in the field of criminal prosecution. Third, the table that I was referring to reveals that new custody time limits have been introduced. And I'm very happy to note from other sources of information that those pre-trial detention limits have even been enacted. My question would be, how are those pre-trial detention limits enforced? And do members of the judiciary, do members of the public prosecutor's department, do officials receive the necessary training in applying the pre-trial detention limits? We are further informed, that's my fourth point, that the Criminal Procedure and Evidence Code and the Child Care Protection and Justice Act provide for a wide range of measures that can be used to prevent detention of suspects and to help a quick disposal of cases. And such measures are also provided for in Article 25 of the Penal Code. And you would say that's a very interesting way out, but we do not have any statistics, any factual evidence of whether those measures are used and in what situations. Fifth, I was very happy to note today and to listen today to the head of delegation who referred to the Legal Aid Act. But I was somewhat concerned that in paragraph 27 of the responses to the list of issues, the committee is informed that the Legal Aid Act does not allow all persons in police custody and detention on remand to be assisted by a lawyer. And today, the head of delegation, the Solicitor General, gave already a number of criteria that are being used in determining whether or not someone is entitled to be assisted by a lawyer. And I would like to ask her, through you, Mr. Chairman, to elaborate a little bit more on those criteria and to inform us, the committee, who decides whether the criteria for legal aid have been fulfilled. And I do hope, Mr. Chairman, that you allow me to raise one other issue. And that is an issue which I think is very important from the perspective of the Covenant. It's an issue which was not raised in the context of the list of issues. So I may be out of order, and as soon as that is the case, you tell me, Mr. Chairman. But I do think that since we are discussing the initial report of Malawi, and since we can benefit so much from the presence of the Solicitor General of Malawi, that would be proper to raise that particular issue. and that is the issue of maternal mortality and abortion. A very important issue, not only from the context of the CEDAW Convention, but also very important from the perspective of the Covenant on Civil and Political Rights. Article 6, the obligations of the state to protect life. Article 7, the obligations of the state not to engage in practices of torture or other forms of maltreatment. The obligations of the state to treat men and women equally. And for that reason, I'm raising this particular issue, and I do hope that I'm in order, and I do hope that the delegation would also not mind to reply to my query, and that is the query about the criminalization of abortion, the criminalization of women undergoing abortion, which leads many women to seek for clandestine abortion, which leads to a situation in which maternal mortality is at the highest rate, I think, around the world in the context of Malawi. And I do know that efforts have been done, are underway to change that situation. And my question to the delegation would be whether you could inform us what measures and what steps have been taken since the CEDAW Committee in 2010 recommended the state party to review the laws relating to abortion with a view to removing the punitive provisions imposed on women who undergo an abortion, providing them with access to quality services for the management of complications arising from unsafe abortion and reducing maternal mortality rates. Thank you very much, Mr. Chairman, for completing also this last issue. Thank you.
Thank you, Mr. Flinterman, and colleagues are absolutely in order, especially at the level of the initial report, to raise issues that we may have overlooked at the time of the drafting of the list of issues. Obviously, we have to give a little more flexibility to the delegation, if necessary, in terms of their eliciting the necessary information themselves for the purposes of the response. Two more speakers on my list, and I'm afraid I have to ask them to be as brief as they possibly can at this stage. The first is Mr. Situl Singh. You have the floor, sir.
Thank you. Thank you, Chairman. I'll be very brief. I also welcome the delegation from Malawi, and also welcome all the recent steps they've taken to promote human rights, and do wish them a successful implementation of these new laws they've mentioned. My two remarks relate to the Human Rights Commission. For a number of years, the Human Rights Commission had been accredited status A with the International Coordination Committee. And when this institution came up for reaccreditation, unfortunately, it was downgraded. So my question is, what can the state do in this case to help the institution regain its status A when the application is examined again? And in that context, when I look at paragraph 15, in relation to issue number 5, I see that this same Human Rights Commission, which according to the delegation is under-resourced both financially and in terms of human resources, is having to help those people who've been sentenced to death to make the applications to court to have the sentence reduced. So I was wondering whether it should not be for the Ministry of Justice to help the people sentenced to death to have this mandatory sentence reduced instead of entrusting this work to the Malawi Human Rights Commission. My question is also whether in Malawi there is a commission on the prerogative of mercy, which could help in that respect. And one final question or remark is related directly or indirectly to issue number 4, about these widows and then sexual cleansing rituals, etc. My question is whether in Malawi there's a problem about albinism, which is a topic which has come to the fore with the latest resolution of the Human Rights Council, whether there's a problem with albinism and with the treatment of albinos. I thank you, Mr. Chairman.
Thank you very much, Mr. Sital Singh. The next and I believe last speaker before the break is Mr. Shani. You have the floor, sir.
Thank you, Mr. Chair. I also promise to be very brief. I welcome the delegation from Malawi. My question, like Mr. Flinterman, does not arise directly from the list of issues, but it is, I believe, very close to some of the topics which have been raised from the list of issues, and it pertains to gender equality. And I welcome the State Party for the new bill, the new act on gender equality that was passed last year. I have a specific question, however, with regard to the information provided in paragraph 11 to the initial report, where the State Party has maintained that Section 24 of the Constitution provides full and equal protection to women in a variety of fields, including the capacity to acquire and retain citizenship and nationality. And my question actually goes to the issue of the Citizenship Act, and specifically to Section 9, which has a specific arrangement for women, which does not apply for men, concerning the retention of citizenship after marriage to a non-Malawi citizen. And the question, does the Constitution override this provision? Is it nullified by virtue of the constitutional provision, or whether the state has to take measures to amend this provision, and if so, is it planning to do so in the foreseeable future? Thank you very much.
Thank you very much, Mr. Shani. Just one technical point for the record. It doesn't affect the need for the question in the first place. My understanding is that the Human Rights Commission has not lost its accreditation. It just hasn't yet been granted the re-accreditation. The process is being suspended, as I understand it, from the office. But the underlying questions raised by Mr. Sital Singh remain there. What are the issues behind the suspension and how they're going to be resolved? Did you want to come back, Mr. Sital Singh? No. Okay. Yes.
I just wanted to say the state, it has got a reserved status now, yes. It is under reconsideration, as
exactly,
you say. Yes.
Exactly. Just wanted to clear it for the record for future generations of historians who look at our summary records, if somebody ever does. Right, it's 22:05. It's now time for the delegation to have its break to concert how it's going to respond to the questions. 15-minute break, 5 to 5, we resume to hear the delegation's responses. The meeting is suspended.